Under such circumstances, this court is of the view that the writ petition fails and is not maintainable in view of the statutory remedy prescribed under the Act, and in the absence of any material before this court as to why the statutory remedy prescribed will not be an effective remedy for redressal of the genuineness of the case of the petitioner. However, keeping in view the claim having been made by a medical doctor towards gratuity and denial of the claim of the respondents, the matter stands disposed of, with a direction to both the petitioner and the respondents to appear before the controlling authority prescribed for the state of Assam within a period of 30 days from the date of receipt of a certified copy of this order. Prescribed controlling authority will thereafter proceed to make necessary inquiries if required, and thereupon pass appropriate orders to the claim or admissibility of the claim for payment of gratuity under the Payment of Gratuity Act 1972. Aggrieved party may thereafter prepare an appeal as prescribed under the provisions of the Act. The question of whether a medical doctor can be accepted to be an employee for the purposes of payment of gratuity is left open to be decided in an appropriate proceeding. Writ petition accordingly stands disposed of in terms of the above order. Yes. When was it last listed?
No.
Fresh motion will come on its own. Will come on its own if it is if there's no defect. Huh? All right, it will come on its own. No out of turn permission.
Wait,
Yes.
please, item number 9, pay for an adjournment today, my lord, sir. I have taken consent of the other side. In this matter, we have filed an interlocutory application yesterday, my lord.
Item 9, the request of the counsel for the petitioner be listed next week.
Counsel for the respondent, my lord.
For the respondent.
Respondents, my lord.
Respondent. Be listed next week.
Yeah, deeply obliged.
Yes.
I beg to pray, my lord, these two interim application, my lord, for listing of tomorrow, my lord.
Why?
Main cases are listed tomorrow, my lord.
Tomorrow.
Yes, my lord.
We'll see. Give it to the court master. Yes.
Lordship, I beg to mention item number 13 to 15 as well as 16 to 19. Your nothing on the application. We have given the
All right. It will be adjourned after 2 weeks. or 3 weeks.
possible can it be Thursday, coming Thursday?
Coming Thursday, we'll give a date. You take it from the court master. We'll have to check the calendar. There are other matters fixed. Yes.
69 days interim.
Sorry?
16 to 19 days interim.
Interim order will continue. Mr. Chaudhary? Yes.
Lordship, I beg to mention a listing of a writ petition in admission column. The matter is that the petitioner's patta land was taken by PWD for construction, and as of now, no compensation.
All right, it will come next week. Yes.
My learned friend was supposed to indicate the time frame.
Yes.
Already we are having a communication, so can it be taken up after some time?
After
Sir, I am for external two losses. Sir, operational sale losses, services computer losses. Operational dated 22/11.
So should be listed for admission.
Admission loss.
Matter be listed for admission after 1 week. Mr. E.J. Soikia appears for the petitioner. Mr.
S of for 2.
S of respondent. As services, as office note says, reflect service note is complete. Service on respondent is complete.
Date losses because I am suffering losses.
On a date to be fixed by the registry next week.
May please, should the petitioner instructed to withdraw this arbitration petition?
All right, heard Mr.
SRN Nasir.
S.I. Nasir,
SRN
S.R.N. Nasir, Council Commissioner, who on instruction submits that the petitioner does not wish to press this arbitration. Accordingly, the arbitration petition stands dismissed on withdrawal. Mr.
W. Sharma Law.
W. Sharma appears for the respondent.
Highly obliged. May I please? In this case, Your Lordship, we have served a step through register post with 80 on 7 March of 2024.
Sir, await this service
Lordship,
report
but-
on respondent. You are for?
For the contender on behalf of K. Gogoi. So already the amount that he has been claiming has been sanctioned. So I think case may be closed on the ground.
Where is that order?
Yes.
Where is the order of the High Court?
Appointed part at page 12, Your Lordship. Oh, sorry, Lordship. Not 12. Page 13, paragraph number 10, Your Lordship. Down below. Your Lordship. Start from paragraph number 10, Your Lordship.
Has it been released or not?
Not really.
Amount not released, it has been sanctioned. Finally, it has to be released from the revenue and disaster.
Then how do you say it is complied with?
Only the sanction has been done, and accordingly the rest will follow.
You said the matter should be closed because it is complied with.
Once it is sanctioned, ultimately the revenue will disburse.
Please read the order.
Revenue, particular. Huh? Notice board.
We heard Mr. S.I. Akhar, Council Commissioner, Mr. S. Borwa, appearing for respondents 2 and 3. 1 and 2. 1 and 2.
One and two.
With the respondent. Both or which respondent?
Two. 1 and 2.
Only two.
Respondent number 2.
District Commissioner.
He has by order of this court.
24/4/2023.
21/4/2023 passed in WPC number
4342/2023.
4342 of 2020. The writ petition was disposed of. the following direction, para 10. Right. So, after notices having been issued in this contempt, the petitioner has, the respondents have placed before the court the order dated what is the name of the person? What is the name of the
Sukhia.
petition?
Respondent number,
Sukhia Begum.
Sophia Begum. Petitioner Sophia Khatun, alias Sophia Begum.
The ex gratia amount is directed by the court, has been sanctioned by order dated, order number so and so dated 12/3/2024. Copy of the state sanction order is to the court. In terms of the direction, since the sanction of amount of this black ex gratia has been issued, this comes to the view that the direction as issued by the court, although delayed, has been complied with. That view of the matter, contemplation stands closed. The
Lord,
notices
may I
issued are recorded.
Respondent number 1 is not complied. Respondent number 2 is complied. So as per direction, respondent number 2 will forward the proposal to the respondent number 2.
Without forwarding, how the sanction could have happened?
Yes, Lordship, respondent number 2 will forward to the revenue department. Revenue department will
Have you shown him the copy of the order?
Lordship, just deposit me account. This part is there. Just sanction Lordship, how it cannot be, how it can be.
Have you seen the sanction order?
No, Lordship.
What is this? This is the order.
Lordship, this is the second page.
This is the order.
Probably he should. Lordship, we have make two party here. Revenue department. and-
Have you seen this order or not?
No, Lordship.
This order dated. Why don't you give him a copy?
Lordship, only one copy is there.
So you take it. Huh? Give it to him. Show it to him. A copy rakhi do. And a line order by the state order amount has been shown to be sanctioned. In respect of the petitioner, also indicating the bank account. Closed. A copy rakhi. Yes. Communication kept as a part.
Stop.
Madam, this item was fixed to know the outcome of the decision of the Honorable Supreme Court.
Why the IA has been filed?
IFR, the early hearing, madam.
Oh, early hearing.
Lordship, can it be taken up at 2 Lord?
So the IA is there. We'll fix a date for hearing.
Yes.
Mr. R. Hussain, learned counsel, hearing for the petitioner. MS
B. Devi.
Huh?
B. Devi.
B. Devi, appearing for the respondent number 2 and 3. Sorry, 1 and 2. Railway.
Railway.
This application is filed for early hearing of the petition filed under section 11 for appointment. During the pendency of the writ petition, arbitration petition 18 of 2019, submissions were made from the bar that the question of the right of waiver of an affected party under section 12(5), the Arbitration and Conciliation Act, was being considered by arbitration bench at the apex court. Therefore, the matter was deferred. So, subsequent, the Constitution bench having rendered the judgment. Do you have the date of the judgment?
8/11/2024.
8/11/2024. in civil appeal number 9486 9487 2019. The matter, the arbitration petition pending can now be heard. So since the matter was not heard, his IA has been filed, praying for early hearing. Accordingly, let the matter be listed on 9th of December for hearing. IA accordingly stands allowed and disposed of. Arbitration to input is the arbitration will be listed on 9th for hearing in view of the order passed in IA number 12.
Next, similar order.
Okay, similar order in item number 6.
Yes.
There the IA is 2831.
Yeah.
For early hearing.
Early.
Okay, same order. IA cannot on 10, on 9.
9.
May I please? If the petitioner lordship approach the Honorable Court lordship seeking lordship allotment of certain land lot, and they were evicted lordship, and before that they have filed representation and approached before the revenue board lordship, and revenue board has directed the revenue authority to dispose their representation, and till then no eviction shall be done. In the meantime, lordship, eviction order were passed lordship, and they have been evicted.
Yes.
The petitioner filed this petition lordship seeking lordship allotment of settlement of land, and in the meantime, lordship, during the pendency of this case, lordship, the state respondent has filed affidavit saying that since the lands were PGR land, so they have been evicted. The petitioners have been evicted as per the Supreme Court's direction in Japal Singh judgment.
Yes.
Lordship, now, lordship, this is since they have been evicted, lord, and the land has been declared by the state that as it is a PGR land. So thereafter, I have filed a RTI application taking the notifications regarding PGR lot. That in that reply, the state has said that there is no the notification is not available. That's the another matter. Okay. Now, lordship, since the lands are PGR lot, we cannot claim right over that. So I am saying, lordship, that the state respondent may, lordship, consider our application afresh, lordship, as per the new land policy. And in the in such similar case, lordship, this honorable case has passed an order, lordship, in a case where, lordship, the state has been directed to take a fresh call, lordship, with a fresh application. If I am paying at this stage, lordship, in this line, lordship, I may be given a chance to file a fresh application under land policy of 2019, and they may consider my lordship application.
Yes, Mr. Porua, have you seen this order? Similar instruction was issued or what? The government has taken a stand. Paragraph number?
But government has taken a stand that since the PCR land, they have been evicted as per the direction of the Supreme
Which paragraph?
Court. Find that paragraph 7, Lord, phase 2 of the PCA.
Right. We dispose it of then. Third, yes. Pass on. Yeah, okay.
Deeply obliged.
Record has come in. So, beyond the time of the two record has come in.
Have a look in the presence of the council if they want. Any objection?
No.
You're for the petitioner.
Regarding land acquisition compensation between a landlord and tenant,
Record item.
the that may be on Canada will verify the office junior to
All right. Whatever.
We also may be permitted to have a look.
If you want to have a look into the record subject to no objections from the government advocate, then have it in the presence of the court. I mean,
Yes.
council as well as the court.
Yes, we'll have a look.
You can have a look
Okay.
between council.
अपना
Third, senior counsel appearing for the petitioner and the counsel appearing for the private respondent.
Yes, ma'am.
As well as, yeah. In terms of the earlier order, the records pertaining to record of what?
record of land acquisition
Land acquisition proceeding.
and my lord tenancy proceeding. My lord.
Temporary settled areas. Record of TSA 17 of 2013 as well as LA case number 1 of 2018 has been called for and the same are available before the court. Council seek time to complete their instructions with the matter and pray that the matter be completed on some other day. Accordingly, it's again in January. Matter be listed on 21st of January.
My lord, there is an interim order.
Mr. Sunil appears for the respondent number 70.
In the
Interim
meantime,
orders passed earlier will continue
in the meantime, we may be permitted
till
to.
the next date fixed. The parties may exchange the pleading and also peruse the record if required in the presence of the court martial. Yes,
Lord, if the petitioner organization is a wholesale consumer cooperative society active in the Gwalpara town and doing business of PDS article within the jurisdiction of Gwalpara town. Lord, if To ensure the proper distribution of PDS article, the authority has developed a specific mechanism. There is a two-tier mechanism. First, the articles are being allotted to the wholesale consumer cooperative societies, Gapanchayat Samabay societies, and local area multipurpose Samabay societies. The three categories of our organization are being considered as a nominee of the government regarding business of the PDS article. And the second phase is that the articles which are being allotted to those organizations, it is being lifted with the help of the designated transporter. In my case is that I am the only wholesale consumer cooperative society having wholesale license in the Goalpara town, within the jurisdiction of Goalpara town, but the authority is allotting the food grains to a designated transporter who is not authorized to do business with the PDS article. And more particularly, earlier I had a 86, 87 number of fair price shops, and when this organization came to existence as a transporter, then the authority has taken away 67 number of fair price shops from my organization and tagged to the transporter. But you will find the page number 23 of my petition will show that earlier I had a 87 number of fair price shops. Page number 23, Lordship. And the serial number 13.
By which order were you allotted these shops?
This is here in the page number 23. It shows that MSW, that is Goalpara Wholesale Consumer Cooperative Society, number of fair price shops agent is 87. And these are the allotment remaining. And Lordship?
Yes.
We come now on the page number 47 and 48. This 47 is the relevant. It shows that entry number 22, Goalpara Wholesale Consumer Cooperative Society is only 20 number of FPS. And the another, that is the fair price shop dealer carriage and contract cooperative society limited. Dealer carriage and contract cooperative society limited has got 74. Then I made a representation to the deputy commissioner, highlighting the fact that fair price shops which are tagged with my organization, they have taken away and attached to an organization which has transported. Then the representation was forwarded to the assistant registrar of the cooperative society for his opinion. Lordship will find the page 24. If my 24 is my representation, page 24.
Yes.
Then here I'm not going to read out because it is a big representation. The core issue which I have highlighted, that the FPS have taken away from my organization and tagged with the transporter. And Lordship will find that page number 54. It is the opinion
No,
expressed.
you tell us what is your right. Is it pursuant to provisions of an act or a rule that you are entitled to have that many number of shops?
No.
Once
Number of shops is not the rule, but rule says that section 6 of the Cooperative Society Act says that if a organization working
cooperative society. Section
6(3).
6(3).
Subsection 3. No society shall be registered under this act in an area where there already exists another cooperative society with similar objective.
But there is a proviso.
Yes. Provided that the registrar may allow registration of more than one cooperative societies in the same area of operation in case the need or necessary demanded for organization for such type of the societies requires the registration of more in the same area operation, that is the transport cooperative, labor contract cooperative, trading cooperative, and housing cooperative. This is important.
Hmm.
Transport cooperative, labor contract cooperative, and the housing cooperative. That is, cooperative societies may be registered for those purposes only, and which is more clarified in the page number 54. The registering authority, the assistant registrar himself clarifies.
What is your society?
Uh,
Under what category?
Gwalpara wholesale.
I'm not asking the name. Under what category does it fall?
My category, I am in wholesale license. Lordship will find the wholesale license. I have that I have an page number
You are
13.
registered under which provision?
Under the that license is there, it will be available in the license lordship. Page number 13 is the license. The license is given by the public distribution order, and my society is registered under the Cooperative Societies Act 2007.
All right.
Then lordship,
Are you challenging the registration
no,
given?
no. I am not on that.
Hmm.
I am that the allotment. I am on my core
So
issue is the allotment.
that's what we are trying to understand. On what basis are you challenging this allotment? On what
Because-
basis are you saying that this allotment having been taken away has violated your legal rights?
Yes. Because lordship, that is why I am trying to peruse the page number 54.
54.
Yeah.
Of the
54 of the of
Affidavit.
my additional affidavit. Page is,
Additional
is running page number 54.
All right. Yes.
It is the opinion is given by the Assistant Registrar Cooperative Societies, Gwalpara. It is in response to my representation which was provided to him. Sir, with due subject with reference to the letter under reference, I have to inform you the fair price soap dealer carriage contract cooperative society is not registered as wholesale consumer cooperative society. So if
That particular cooperative society,
for transportation,
no, who's
and it is
who have been allotted the fair price shops which were earlier operated by you. You're referring to that cooperative society.
sorry, I can get you that point.
This cooperative society not registered as a wholesale cooperative society,
Yeah.
is that society who has been allotted these fair price shops which were earlier operated by you.
Earlier, yes, earlier operated. And Lordship may peruse the page number 60. It is given a wide clarification there. Again, that it is a communication issued by the assistant registrar.
Page number
60, Lordship, 60.
yes.
I'm just subject to this reference that which was provided. Third, with humble submission, I beg to state that Gwalpara Wholesale Consumer Cooperative Society, represented by its chairman and secretary, accompanied by a number of members and public, filed a petition today on so and so. Petition is self-explanatory. This is my representation. That's all. You may kindly note the following points pertaining to the referred allotment order. That's the LOT number 24 of the allotment order is fair price dealer carriage contract and cooperative society registered on 31st August 2016. That's the said cooperative society cannot do business of PDS commodities. So this is important. Registrar is telling, this is the registering authority. the state cooperative society cannot do business of PDS commodities as per clauses of their bylaws and provision of the Assam Cooperative Societies Act 2007. And which is the provision? It is explained in the next page, page number 61, clause 4, Lordship. That's that if the referred cooperative society, that is,
Who appears for respondent number 5?
his name has been struck down by this honorable court itself.
Why?
The court observed that as I am not taking any relief against him, so his presence may not be necessary. It is in the first order reflected, Lordship, the motion stage.
And what is the stand of the affidavit in the government?
This is important. Affidavit they have filed, and their stand is reflected on the page number 34, paragraph 6. May I have your permission to read the paragraph?
Of
Lord?
course.
Running page number 34.
They have stated both are cooperative societies having equal rights and privileges.
Yes, but yes, they have stated, but the registrar who is registering the cooperative society, the registrar is telling that no, it is not registered as a wholesale consumer cooperative society. It is mere a statement made in the affidavit, and which is the official communication issued by the authority who is authorized to register the society.
This is filed by whom?
This is filed by the
Food and Civil Supplies.
yes, Food and Civil Supplies.
Who's for the Registrar of Cooperation?
Registrar of Cooperative Society is not a party.
Then why have you not made party?
Lordship, this is because that the representation that I have made to the Deputy Commissioner as well as the Food and Civil Supply Department, and that representation they have forwarded to the
Yes, what
registrar.
do you say?
Make kindly go to para 7 of
One more thing, Lordship, I just before this, one more thing I want to make clear, that there is a two tier. First allotment, then transportation and lifting. I am on the allotment. Transportation as lifting is not my subject, and I am not entitled to lift or transport the commodity from the godown. And they, in their affidavit, they have elaborately discussed that I am not entitled for the transportation. All right, it is not my issue also. I am not entitled, I am not claiming to be a transporter. My issue is that allotment. Allotment cannot be given to a transporter which is not registered as a wholesale consumer cooperative society, because I am active. In fair price shops which are earlier tagged with me, they have taken away and tagged with the new entity who is not registered.
Yes, respondent, what do you say?
So he is objecting to the fact that some part of the paper stock has been taken away. The reason he is explaining that no reason has been assigned to it. But the reason why the government has taken that decision has been enumerated in paragraph 7. So we
He
have
is
made
aggrieved that you have taken it away, given it to somebody who is not registered.
No, no,
That is what.
no, that is his contention, but that
No,
is
no, no, that is not his contention. That is a communication from the office of the assistant registrar at page number 54.
54 of
It's very clear that they are not registered as wholesale cooperative society. They are the registering authority.
so far, diversion of agents from Goalpara also this office has no papers, size dealers, carriage and contract cooperative society is not registered as wholesale consumer society. Assistant registrar of cooperative society.
We can't permit you to prepare for hearing only. Either you are ready for hearing, you are not ready.
So give us something.
But the matter is that you are not, should be ready for this.
Also
You
give
have
me,
filed your pleading.
also give me something. I will do within the
Thursday.
Thursday, next Thursday, not
Coming Thursday. Twenty-eighth.
28.
Matter be listed on 28th at the request of council preparing for the government. Yes.
Right.
Yes, Mr. Borova, what instructions have come? Tell us, tell. In court, there is nothing secret.
No.
Whatever you have, you say it.
No, just now I have got the copy.
You have not even gone through it.
During the course, I was with the other case.
We'll help you to go through it. You share one copy with the counsel for the petitioner, give us one copy.
তুমি ফটো আমি এটা লৈ যাম আৰু ফটো এটা দি দিম। এইটো কোন তাৰিখ?
Put up the money. The instructions we sought for was whether you can give them 2 months, 3 months, whatever time they're asking for. This is a vague objection you have raised.
Basically, they are on their earlier stand. Lordship can give us some reasonable time, my lord.
This is by National Highway.
Yes. NHIDCL. NHIDCL.
NHIDCL. So,
Here the Lord already coordinate bank, he has paid earlier to this rejected time. Because
No.
already we have deposited this 1,13 crore. It's
forget
already
on that.
deposited.
We are only asking you instead of 3 days, 4 days.
Because already we
Some
have
reasonable
No,
time.
that's all right. You
due to now
we are
the-
not even remotely questioning your commitment to the project. What we want to know is in this X part of land, you are not starting from this X part of land. You are starting from somewhere else. So now, how far has it reached? So that you need this the possession of this land to carry on in the work. We expected that kind of a
No,
instruction.
because whatever instruction is to me, my lord, as an executive council. What happened is already not my submission only. Satisfaction. Because whatever it has been told me. Already whatever amount, compensation amount that is already deposited.
That is
No,
irrelevant.
I'm coming.
No, that
I'm
is
coming.
irrelevant.
Because
That is irrelevant
and,
because we are not going into the
that
merits.
that is now giving time, we had given him sufficient time even
Again,
for
you are going
even
back to
for
merit. You are
even
again going
assuming
back to merit.
Even
If you don't have the instructions, we'll give you time till 2 o'clock. You get your instructions, then we'll close the matter.
one instruction, my lord, whether only this portion is left.
We are asking you is that you have given him a notice to vacate in 3 days' time. So we are only asking you whether
Only this portion is left or any other portion is left.
no.
How much time you can
No, time will come later. Lordship
how
queried
much
me.
time you can give him so that he can shift. He
Vacate.
has already identified the alternative place.
works are going on?
That- Now, because what instruction is given, because last instruction is to him, I am not seen also. But on my instruction, then if whether Lordship will rightly question me,
We are
because
giving- we
rightly
like-
inquired,
we will-
only this portion is left.
We will give him 2 months' time.
No,
60
2
days.
months
Yes.
time because it is be difficult for us. Because already
What
work
do you
has
want to
been
know? Why is it difficult for you?
November to only March we can work. This is the work that left it. Now at Lordship may take it 2 o'clock.
Mr. Counsel for anything here, I have great regard and respect for yes. But please don't tell me that this is the working season, whatever work you have to do is completed. We have seen it here somewhere.
No.
Not it,
Is correct. But
including our
this Lordship, how much time they can give me? May I take some time from my side, pray for take 2 o'clock? I'll query, make it
we'll
query.
give them 60 days time.
And at
Yes.
2 o'clock it is, let me take. I'll take instruction.
Time for instructions.
No. I have to take instruction, Miller. Regard may maybe taken at 2 o'clock.
60 days is good enough.
Yes.
No, because it is this another matter is also 15, 16, 12. Same matter, same issue.
Maybe
I'll make it 16, 12 it is issued. Coordinate branch is speaking on 16, 12.
whatever it may be. We are only asking you how much time that instructions if you could have given us.
That's why, my lord, I may be allowed only 1 hour time, 2 o'clock it may be. 2 o'clock.
We'll give them, they are praying for 90
That's why,
days.
Lordship at 2
We are
o'clock.
inclined to give them 60 days.
Yes.
My lord, my submission may be recorded that time, 2 o'clock. His Lordship pleases, whatever pleases. Because I am also being a standing counsel. I have to also take instruction. This much I will place before Lordship at 2 o'clock.
All right.
2
But we
o'clock.
are making our
No, I'll communicate this
intention
also,
very
my lord.
clear. 60
Lordship's
days.
pleasure also I'll communicate.
Yeah.
I'll definitely, but maybe taken at 2 o'clock.
At 2 p.m.
My lord.
At the outset, I must bow my head for Constitution Day and Law Day before there.
But we didn't see you in the program in the morning.
Sorry. Lord, I have one request here. I have been some problem because some new guests come inside,
Okay.
and therefore may I urge your lordship that my junior will please address your lordship on
Yes. No problem.
this Zova.
Yes.
Thank you, Your Lordship. Uh, I have got some judgment in reference to the issue which was raised on the last day by the Learned Counsel for the opposite party regarding the notice issued by the advocate. On that point,
Have you submitted here?
yes,
You submitted.
yes. I have submitted two, one on the last
It's
day.
2005.
2017, Lordship. SIT Infracon Private Limited versus the Union of India, September 2017.
2017.
17. Yes.
TRF.
Guwahati High Court, order, judgment. Lord.
I don't think.
The party name is Infracon, Lord. SIT Infracon Private Limited versus the Union of India. RGP, I've submitted today. And another one on the last day has submitted 2023 7 SCR 59.
Not here. They are submitted physically or through email?
To email.
Or through email.
And one has submitted a physical copy.
Email. No one. Yes. Which paragraph?
Lordship, to permit, if I can take a soft copy of this.
Whatever. Yes, I did.
Lordship, refer. Uh, I would like to refer to para 22, 23, 24. If I may read out the para.
Yes.
Para 22. The expression, unless the context otherwise demands, cannot simply be wished away. Though Section 2H provides that party means a party to an arbitral agreement, such definition cannot be confined to a watertight compartment or a straitjacket formula applicable in all circumstances. If the context demands and warrants, the import of the word party can be judicially expanded so as to conform to the needs of the situation. That is, and para 23, in an adversarial system of litigation, the lawyer plays a pivotal role and they espouse the cause of a litigant. According to the perception of the court, it should be endeavor of every court to promote justice, and it would be a necessary concomitant to interpret the means of achieving justice in a pragmatic manner. In Maxwell's interpretation of statutes at page 99, the learned author had underscored that provisions regarding giving of notice often receive a liberal interpretation. The thrust of clause 64, that is the agreement between the parties, 64.1, subclause 1 of the GCC of contract is on the need to make a demand. Clause 64.1.1 of the GCC, which requires the contractor to raise a demand in writing that the dispute and difference of be referred to arbitration, ought to be given a liberal interpretation. There is another judgment which we had referred, where the Supreme Court had allowed or appointed arbitrator on the basis of notice invoking arbitration, which was issued by the learned advocate. It's actually the authorized agent.
Was the issue right there? Whether
No, that issue was not raised, but in this case, it has been
it
fairly answered.
but there's no reference how, right?
Section 21 of Arbitration Act also, it never refers to or prescribes any format as to the notice, who or how it should go.
No, their contention is that the by a part
Such a party is what the Honorable Supreme Court has
you
tried to
referred
interpret.
that with the judgment of NRSC Krishna Commission.
So Benassi has been referred by the respondent in this case, but that is in reference to Section 35, where they are saying that the copy of a judgment was handed over to the counsel of the party. So that is a completely different context. In this case, the petition,
This is the only judgment to refer.
but the others where this is the only judgment where the court has interpreted the term party. But otherwise, where the Supreme Court has allowed.
How is it different? May not have been objected. The arbitration, arbitration is the nature of a contract,
Right.
and it's the mind of party decide. They decide that all right, it is good enough. Good enough. Now, unless the question is raised before the court and by right,
Absolutely.
cannot be held to be an authority on that.
Okay, then this infratext,
This is
court-
one,
this
but
is one. Right.
I'm asking,
Any other?
there are better judgments on it.
Even if we go by section 21 of it, there's no mention of prescribed format for that should be issued by the
Format
party.
is different.
Or-
Where the act is very clear. Where the act is very clear. You will have what extent can you expand the scope of the definition?
There can be judicial expansion of a term wherever context requires my humble submission. Because again, Arbitration Act, the very purpose of it is that the parties, it, should be rendered justice on regarding. If the interpretation is made in a liberal context, Lordship, there is no party, there is no harm to the other party, Lordship. Nobody, there's no prejudice against the other party. But if it's narrowly interpreted,
Where is you read the section? You read the relevant section.
Section 21, commencement of arbitral proceeding. Unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. It's just a request, Lordship, whether it's written or not written, or whether who has been. And if we even refer to the agreement between the parties, the word party itself includes the agent of the main contractor, Lordship. Even if we go by the contract or agreement between the parties, it includes his agents.
Yes.
So the arbitration notice is in fact, my lord, it's a very vital.
The judgment placed by the
Yes, my lord, that judgment I have, my lord. In fact, my lord, what I have been informed, lord, that judgment is now challenged also. Supreme Court, my lord. That judgment has been SLP,
SLP is pending
not pending, my lord. It is in process of filing.
after it has come to your notice.
No, my lord. Prior to that. Prior to that. This judgment, my lord, Mr. Kaustubh Gogoi, my lord,
Yes,
he appeared, my lord. My lord, regarding the term party, my lord, my submission is that, my lord, section 21, which deals with commencement of arbitral proceedings. My lord, it's a very important stage, my lord. My lord, if I may read the section once again, my lord. Commencement of arbitral proceedings unless otherwise agreed by the parties. My lord. It starts with the clause, my lord, unless otherwise agreed by the parties. And the word parties, my lord, then, my lord, has to be linked with the definition of the term.
So you must show us with some authority.
Yes, my lord, authority I will come, my lord. Before, I'm just trying to build up my argument first, my lord.
No, your argument will be built up provided you come up with some authority to say that no party described under
Yes,
section 2 means only the party to the
my lord, the judgment
and
which I have
excludes
relied.
all agent.
Yes, my lord. My lord, the judgment. Here, my lord, in this judgment, the Honorable Supreme Court has interpreted the meaning party as defined in section 21H, my lord. Although it was in context of section 34, my lord, but the term party under section 21H has been, my lord, interpreted,
Paragraph.
my lord. My lord, paragraph 6. My lord, paragraph 15 to 17, my lord. If I may read paragraph 15, my lord.
Yeah.
Having taken note of the submissions advanced on behalf of the respective parties and having particular regard to the expression party as defined in section 21H of the 1996 Act, read with the provisions of section 31(5) and 34(3) of the 1996 Act,
we are not inclined to interfere with the decision of the division bench of the Delhi High Court impugned in this proceeding. The expression party has been amply dealt with in Techi, Tecco Trichy Engineers case and also in ARK Builders Private Limited case referred to herein above. It is one thing for an advocate to act and plead on behalf of a party in a proceeding, and it is another for an advocate to act as the party himself. The expression party as defined in section 21H of the 1996 Act clearly indicates a person who is a party to an arbitration agreement. The said definition is not qualified in any way so as to include the agent of the party to such agreement. Any reference, therefore, made in section 31(5) and section 34(2) of the 96 Act can only mean the party himself and not his or her agent or advocate empowered to act on the basis of a wakalatnama. In such circumstances, proper compliance with section 31(5) would mean delivery of a signed copy of the arbitral award on the party himself and not on his advocate, which gives the party concerned the right to proceed under section 34(3) of the aforesaid act. The view taken in Pushpa Devi Bhagat case is in relation to the authority given to an advocate to act on behalf of a party to a proceeding in the proceedings itself, which cannot stand satisfied where a provision such as section 31(5) of the 96 Act is concerned. The said provision clearly indicates that a signed copy of the award has to be delivered to the party. Accordingly, when a copy of the signed award is not delivered to the party himself, it would not amount to compliance with the provisions of section 31(5) of the Act. The other decision cited by Mr. Ranjit Kumar in Nilakantha Siddharamappa Ningasetti case was rendered under the provisions of the Arbitration Act 1940, which did not have a provision similar to the provision of section 31(5) of the 1996 Act. The said decision would therefore be not applicable to the facts of this case also. So, my lord, the word party and the definition of party as interpreted by the Honorable Supreme Court, my lord, will apply to the entire provisions of the Arbitration Act wherever the word party has been, my lord, incorporated in the provisions. And, my lord, section 21 of the Arbitration Act is a very vital stage, my lord. It is a stage which starts the commencement of the arbitral proceedings. My lord, it is not a stage, my lord, when the arbitration actually starts, would that be the start of the arbitral proceedings, but it is the arbitration notice, my lord. Therefore, my lord, that notice,
Where is the judgment?
my lord.
Yes. But tell me one thing, where is the connotation party under section 20?
So, my lord, if I may read section 21, my lord, It starts with the language unless otherwise agreed by the parties. Therefore, my lord,
No,
if the
this is agreement is with regard to when the arbitral procedure is likely to commence.
yes, my lord,
Ordinarily, on the date you receive the notice,
yes, my lord,
unless otherwise agreed.
yes, my lord. So therefore, my lord, if that be so, my lord, the word party is there, my lord, unless otherwise agreed by the party.
Correct. But
Yes.
where do you say that it is required to be issued by the party?
No.
The notice is a request for that dispute to be referred to arbitration
Is received by the respondent.
by the respondent.
It also does not say, my lord, that it can be by anyone because, my lord, as lordship has already expressed the view that the arbitration is arises out of a contract between the parties, my lord, and an
Now, if
agent.
the contract in this contract is the party is represented by agents or are the agents required to be included in your contract?
No,
Does it define
no,
anywhere that party means party or is agent and subcontractor?
yes, my lord, this question, my lord, came on the last question also, my lord. There is no specific definition which supplements that within the definition of contractor, any other person would also come. There is no specific, my lord, definition, my lord. Page 25, my lord, of the contract agreement defines the terms and the different interpretations, my lord.
Right? Right. Understand. Judgment you are referring to 34.
No, but it interprets 2-1H, my lord.
Up to that. 34 has a specific reference to a party making the application.
Yes, my lord.
It is in that context whether party is to be is include agent or not was gone in
And
section 34 2A A1
my lord.
sorry 2A
Yes, my lord.
only if the party is making the application.
Yes, my lord. And section 21 also starts with that clause, my
Hmm.
lord. Unless otherwise agreed by the party.
Exactly.
Meaning thereby, my lord.
Unless otherwise agreed by the party,
Yes, my lord. That would
proceedings
mean
in respect of a particular dispute shall commence on a date when a request is received
so, my lord, there
by
is
the
a presumption.
respondent.
Yes,
So therefore,
my lord.
unless otherwise agreed by parties, will be only with reference to the date of commencement, which ordinarily means, if not agreed, the date on which the notice is served. So,
Yes, but my lord, that notice has to be by the party to the contract only because my lord, it starts with the clause unless otherwise agreed by the party. My lord, that agreement cannot be with the agent of the my lord, agent of the contract or the authorized counsel. Therefore, my lord, as this clause starts with the particular line, my lord, unless otherwise agreed with the parties by the parties, the word party would apply, my lord, also to the fact that it has to be sent only.
see, a section has to be read for the, it has to be understood in the meaning, in the plain meaning, if possible. Interpretation comes only when it cannot be understood.
My lord. If we apply
The
the
stress is not on who applies. Stress is on the date we you receive.
yes,
Stress, the section 21,
my lord.
the section 21 to be set in motion is the receipt of the notice by the
Yes,
respondent.
yes, my lord. And
So
that
it is not on who applies,
yes,
who
my lord,
sends,
that
in
is
what
a very
form.
important stage, my lord, and it cannot that commencement of arbitral notice proceedings, my lord, cannot be at the instance of the my lord person who is not a party to the agreement. The commencement of the arbitral proceeding has to be at the instance of the parties to the contract agreement. my lord, it cannot be at the instance of a person who is not a party. Therefore, my lord, since arbitration is a, my lord, special act, my lord, and the provisions have to be strictly, my lord, interpreted.
That's what we are trying to do, strictly interpret section 21.
Yes. But, my lord, since there is a reference of party's word is there, my lord, in that provision.
That is where the parties do not agree.
So that would that
Supposing
doesn't
the
mean
parties,
that would
no,
in
no,
case,
that
my lord.
meaning should have been ascribed in the section itself. It's not there. Plain reading means unless agreed to. Unless agreed to, it is the request for the dispute received by the respondent
Hmm.
to refer it to the arbitration. Is the beginning of the proceeding.
No.
So, request by whom? Party,
Request by a
an
person
agent of
from,
the party.
my lord, my humble submission is, my lord, since it is a very vital stage, my lord, the arbitration notice, from that point, my lord, the limitation is counted. Limitation is also counted, my lord. And that notice cannot be by a person who is not a party, my
Then you'll need more authorities to convince the court on this part.
lord.
These are with specific. Section 34 is very specific that it is to a party who apply.
Yes.
It's a party. So therefore, the court answered the interpretation that
But
party means
21
the party is defined.
is not completely the word party is there, my lord, because if we apply the principle of, my lord, citizen generis, my lord, the word, the meaning of parties would also follow to the subsequent lines, my lord, because it starts with the word unless otherwise agreed by the party.
No, no. Your argument could have cut ice had it been a case that the applicant issued a notice to the agent of the respondent. Then you could have questioned, no, I did not receive. It was to my agent. Therefore, Section 21 was never complied. Section 21 says to the respondent.
No.
Here is a case where you have received it, you don't deny it. Your argument, which you are trying to project, would have been in the facts of a case where the respondent did not receive, but it was served on the agent.
But if you see the chapter 5 of the Arbitration Act, my lord, uh, which deals with conduct of arbitral proceedings, and, my lord, from where the section starts, my lord, chapter 5. This section 21 comes within that chapter, and, my lord, the opening sections, my lord, they all deal with the word parties only, my lord, and there is no clear, my lord, meaning under the act which says that the definition parties would include, my lord, agents also. If that be not there, my lord, then the party meaning of party has to be
So
interpreted
you are going
strictly,
back to your argument.
my lord.
See, you are restricting ourselves to the section.
Yes,
It's not a case that notice was sent to your agent
my lord.
and there was an argument projected by the petitioner that no, respondent could include the agent. And perhaps your argument, you could have made that argument. Here is a case where it's a reverse situation. It does not exclusively bar or restrict issuance of notice by any other person. Your judgments are not on 21. But I think the petitioner's judgment is it on 21?
Yes.
On 21. So you have to distinguish this judgment. Other than saying that some SLP is softly preferred.
If I may reply to this contention, Lordship, they have not denied this, Lordship, or that they have not raised any dispute also, Lordship, as to why it has been issued by an agent, either by a reply to our letter or in the affidavit in opposition.
Now they have raised it.
Lordship, yes,
It's a legal question.
please have raised it, but in the affidavit in opposition, it's not anything like that.
But if the agreement is signed by the party, if the communications are by the party, when appeal against the award is by filed by a party, why is the notice not by a party? Why the difference?
That since there is a legislative vacuum as to what is a party, who's a party, then it has to be
Legislative vacuum will have to be understood by referring to the other sections that trade harmonious.
again. Section 21 simply says that there has to be a request, and party doctor is no such thing as whether the
See,
party
you will have to say that the definition of party in way is only with regard will it only will exclude the agent only with reference to specific sections of the
correct. The judgment he is referring to is only refers to when there is a
so this argument if you want to build up on precedent, not your wish or our wish made on the law. Check precedent and bring
only when the agent can be excluded only in case where there is some prejudice caused to any party. Then
on
it
what
can be
basis
given
are
a
you saying
strict
that?
interpretation.
What basis are you saying?
Lordship, then in this
There is
one,
no question of prejudice, it's a question of agreement. It's an agreement.
Lordship, again, in that agreement also, where we have been submit, there's no exclusion clause. Where section 21 is referring to the first part of it, unless otherwise agreed, we have no such clause where we have excluded the operation of this section 21.
It's a question of whether the
And there is
agreement is signed by whom?
by the party and
By
it
the party.
includes his agent's party.
What from both of the
Lordship, the GCC section clause 64 also says that has to be
is a part of the meeting there.
56 only.
Page
56.
the party has raised the claim set for settlement. Lordship. It is the parties who have raised the claim, not the advocate.
Where?
Our annexure 6, the party has sent a letter, annexure 6, page 92 of the publication. The party has issued a letter for settlement of disputes and claims. Not the
No, where is the section 21 notice?
Lordship, then the last one is by the advocate one, the one issued by the advocate for the petitioner. The authorized
Where have you demanded for arbitration?
Lordship, page 110. Puppet. Page 98, Lordship, we have specifically the letter issued by the party that specifically said that under clause 61 BCC to settle our issues at the earliest.
Page number
98, where we have
91,
98.
98.
the last paragraph.
No, but this is only in the event your issues are not sorted out. Page 98. In case your request is not considered favorable.
So we have, then they have replied to our letter saying we don't have any claim. So
No.
then we had issued the other one. Then there was no reply to this, saying that this is not a valid notice.
Notice is, my lord, a notice that is a pre-arbitral process, my lord. That is a representation to the GM under clause 63.
Right.
If the GM does not respond, my lord, then an arbitration notice as per 64(1)(1), that is section 21 notice, ought to have been issued by the party.
Right.
Although 63 notice was issued by the party, my lord, but the subsequent notice under 21 was issued by a person who is not a party to the contract. And clause 64(1)(1) at page 56, you know, that clearly says it is the contractor who has to.
You see your contract, page number 56. Please read clause number 64(1)(1).
Depend on any construction operation contract on the respective rights and liabilities of the parties on any matter related to the holding by the railway, any certificate to which the contractor may claim to be entitled to, or if the railway fails to make a decision on the case, then such case separate matters record of the contract, the 28.188 present.
Contractor. There's a very specific reference, the contractor.
Right? Every agreement that is specifically
You
written
show us the
herein after
you show us from the definition that contractor includes agent.
Contractor word is not defined. No?
You prepare and come back next week. We'll need some authorities here. Otherwise, contract does not explain, there's no definition of contract in your contract. It is not there.
Fine contract.
Then it's not there. And your demand for arbitration clause specifically defines contractor. Let the matter be listed next week for further hearing. Third. On 3rd. 3rd of December. You give us a date?
Except 3rd of October.
5th of December.
Matter has been fixed on third. I pay for third.
No, my lord. Each contract is having its own arbitration
Let
clause.
it- I will argue on third.
Let me submit, my lord. If your lordship is satisfied, then no need for the adjourning the case. Your lordship may
My
kindly,
part will be on third lot.
my lord,
No, why?
That issue lordship 20% issue.
after
That is already
SBI,
decided by
Yes.
this
But-
bench itself.
yes,
But there is a coordinate bench decision was also there. Lord.
Then you refer it to larger bench if you want. That's argument. That's an argument you
On
have to
third
make.
lordship will be on third lordship.
See,
Because lordship
do you have the references of the cases?
yes, yes.
Where is it?
Lordship, in the reply they have filed lordship.
Reply.
Yes,
Yes, this judgment on 1812.
lordship.
And then you are referring to the other judgment. What is
Yes.
that?
That was arbitration petition 34 of 23, where he was himself as the counsel lord.
No. What is the date of this order?
That lordship 22 to 24.
24. This is a judgment of 22. Earlier, this coordinate bench, page
Yes.
175.
Yes.
Yes.
So this is a case where the court, in spite of the contract, went ahead to
But
appoint.
there is a dispute lordship. This is an item rate contract.
Whatever it may be, have you gone through this order at 175? This was never appealed again.
Yes.
This is attained finally.
it has got
But
to
this is an item rate contract lordship. That's why lordship
Same conditions of the contract. Same confusion as 64 and what 20, 30,
63, 64.
huh?
63, 64.
63, 64. Same confusion.
And my lord, after coming up the judgment of the SBI General Insurance Company, Supreme Court says only existence of arbitration clause is required to be seen, not anything else.
on
If it is
third
admitted, then all issues shall be raised before the arbitrator.
No, but if the arbitration clause says beyond 20%, no arbitration, then
If arbitration clause, other clause, if it is not part of the arbitration clause, if
no.
it is the part,
If there is a clause indeed for arbitration, but only for contracts below 20%,
now my lord,
which is there clear.
yes. Now, in each case, arbitration clause is different, and this embargo is different. So arbitration clause is not there. It is outside the arbitration clause, my lord.
How?
Because this is not part of here. In this case, arbitration clause is 6.0, and embargo is 8.0.
existence of an arbitration, existence of a clause for referring it to arbitration has to be read with all other
No,
attending or relevant clauses.
my lord, my respectful submission is that
If the parties have agreed that we'll go for arbitration, but for contract value of below 20%,
my
20 lakh.
yes, my respectful submission is that they have terminated the contract. All the terms and conditions of the contract perished with the termination. What is left? Left is the arbitration clause. Why it is left, my lord? In view of the section 16 of the Arbitration and Conciliation Act. And
Then it defeats your own argument. That agreement
yes,
for referring it to arbitration is operative only in respect of that below 20%. So if all the other clauses go, that arbitration clause becomes inoperative.
20% is not a part and parcel of the arbitration clause. This is a independent clause. So many clauses are there. And after coming of the new judgment, SBI General Insurance Company, there is no scope, my lord. And your lordship may kindly see this. My learned brother is
What is the
referring
citation of the SBI General?
2024 SCC
Sorry, repeat. Can you repeat?
2024 SCC
Yes.
online SC 1754. And my learned brother is relying on a judgment which is not a good law. In view of because the judgment is based on some Supreme Court judgment, which is deprecated by this three judgments. Your lordship may kindly, I am giving the copy, your lordship.
Hey, well, कागज है कि- Yes.
Now, paragraph 110, I am coming, your lordship. The scope of 110 at page 44. May I read, my lord?
110.
10, page 44. On the head, small, it's written page number 40.
Yes.
100. The scope of examination under section 11(6)(a) is confined to the existence of an arbitration agreement on the basis of section 7. The examination of the validity of arbitration agreement is also limited to the requirement of the formal validity, such as the requirement that the agreement should be in writing. Now this has been confirmed in our agreement, my lord. Now whether my claim is arbitrable or not arbitrable, it will be decided by the learned arbitrator. Now your lordship may kindly come to paragraph 114. The judgment my learned brother is referring is based on NTCP case and Vidya Dorolia. In view of the observation made by the court in re interpret, it is clear that the scope of inquiry at the stage of appointment of arbitrator is limited to the scrutiny of the prima facie existence of the arbitration agreement and nothing else. For this reason, we find it difficult to hold that the observation made in Vidya Dorolia and adopted in NTPC versus SPML that the jurisdiction of the referral court when dealing with the existence of accord and satisfaction under section 11 extend to the weeding out expressai non-arbitrable and frivolous dispute would continue to apply despite the subsequent decision in re-interpolate. Now, based on this, my lord, new judgment, the Honorable Delhi High Court, in a recent judgment, where this type of issue was raised, And my learned brother is referring the judgment wherein this judgment of the Honorable Delhi High Court was also incorporated. In other words, it was also based on this, which judgment has been negative by the recent judgment, my lord. Paragraph 24, my lord. Mr. Seth Floor placed reliance on the judgment of a coordinate bench of this court in BCC Mona Lisa versus Container Corporation of India. Clearly, the arbitration clause in that case was similar in its wording to the arbitration clause in the present case. The coordinate bench has in para 15 of the said decision observed and held thus. Petitioner has not contested that the aggregate value of the claim would exceed 20% of the contract value. The petitioner's only submission in this regard is that the arbitral tribunal will determine whether the claims are non-arbitrable. As stated above, the court, even in this limited jurisdiction, under Section 11, could conduct a preliminary inquiry to find out if the claims are expressly arbitrable. This court is not relegated to the post office to be completely oblivious to the obvious legal infirmities in the request for appointment of arbitrator. It is not enough for the petitioner to say that let the arbitrator decide all the jurisdictional issues. The petitioner must cross the minimum threshold that is required in law as stated above before the court can act upon such request. Respondent, unless it consists such request cannot be mechanically burdened with the arbitration proceeding and the cost attached thereto, even for adjudication of jurisdictional issue that is otherwise apparent at the stage of Section 11 inquiry itself. Significantly, the coordinate bench has in BCCI Mona Lisa noted the contention of the petitioner that the arbitral tribunal was required to determine the extent to which the petitioner claims were arbitrable, and that therefore it could not be said that the claim amount would invariably exceed 20% of the contract value. The coordinate bench has observed that this court was possessed of the jurisdiction while dealing with an application under Section 11(6) to conduct a preliminary inquiry to find out if the claims were expressly arbitrable and could even at that stage work out the extent of claims which could be referred to arbitration. That position, however, does not continue to hold good in view of the recent decision of the Honorable Supreme Court in SBI General Insurance Company Limited versus Spinning, in which the Supreme Court has clearly held that the court exercising jurisdiction under Section 11(6) cannot examine the expressly arbitrability of the claim. The court can only examine whether there exists an arbitration agreement between the parties and nothing else. To quote the exact words used in para 114 of the report, the only other aspect which the Section 11(6) court can look into is whether the petition under Section 11(6) has been moved within 3 years of the notice issued under Section 21 of the 1996 Act. The basic premise on which the coordinate bench decided BCI Mona Lisa case, which was that the court, while exercising jurisdiction under Section 11(6), would examine the extent to which the claims of the petitioner were arbitrable, is therefore no longer good law. Then
Paragraph 122.
yes, my lord.
Paragraph 122.
122 of my lord.
2024.
SBI.
2020 SBI.
Yes, SBI. Yes, SBI.
So the law is set.
Lordship on third lot. Wednesday.
This efficacious or alternative remedy, as soon as everything can be raised before the learned arbitration.
No instructions are necessary. You just have to. We are just waiting for you to
On third
give
lot.
us if there is any other view you
That's
want
why,
to
Lordship,
place
yeah.
before the court in the face of these settled
2020.
position.
Lordship on third lot.
Third?
Third lot.
Right. Third is a good day for him, perhaps.
Lordship.
Auspicious day. Let us keep it for third. The request of Mr. S.S. Roy. Matter stands deferred. Be listed on third for a hearing. Mr. R. Hussain appears for the petitioner.
Arbitration petition 25 of 2020.
Oh, if it is listed, it is listed. If it is not, we'll take it up.
Yes.
So Vidya Drolia has been
Yes. Even
Watered down.
in interplay, it has been struck down.
not struck down,
Yes.
watered down.
Struck. And in this also this constitution bench also in other case interplay.
No, what about the other judgment? 12-5.
Now on 12-5 only now this is 3 bench judgment by not SBI insurance is 3 bench.
Prior or after this?
12-5 is mandatory. It is mandatory.
Not mandatory. The view held by the earlier pre-judge bench
Yes.
is subject to such a waiver.
The waiver. Yes. The waiver in writing.
If no waiver is given, then
Then
cannot be enough.
yes, such arbiter will be ineligible. Even if award is passed by ineligible arbitrator, it can be set aside on that ground.
But only under 34.
Under 30. Otherwise, there is no waiver. Much.
None appears.
May I please, Lordship, kindly adjourn the matter for the Lordship, because my senior, Ms. K. Gayan, Lordship, he has gone through a surgery, Lordship.
What is the matter about?
My lord, the issue basically pertains to two things. My lord. Now, the petitioner before your lordship is occupying a Patta land since 1933, and it was duly settled with him by the authorities, that is the deputy commissioner. And in the year 1990, there was another litigation on the same subject matter, that this land falls within the protected, my lord, boundary of an ancient monument, that is Ebidol, in the district of Gorisagar, my lord, Sibsagar, my lord. Now, this land, the earlier round of litigation, the court has observed that it is far away from the peripheral zone demarcated by the Archaeological Survey of India, and that has been, my lord, the order has attained finality because no appeal has been filed. From 1990 to 2008, my lord, he was living peacefully. In 2008, he constructed a house, my lord, the first floor of the house he constructed. Then in 2008, my lord, a notice was sent to him that you are constructing a house in the first floor, which is again within the prohibited area of the ancient monument, my lord. Then I put to challenge that order. That was stayed by this court, and then they did not proceed. Again in 2015, my lord, they issued another show cause, and in 2015, a demolition notice
There
was
is
issued.
an interim order.
There was an interim order, and that is continuing by the case of this court, my lord, and we are continuing with the interim order.
When is he likely to be back?
In the month of January.
Month of January. All right. You are protected by an interim order.
Yes, my lord, we are protected within the.
It is submitted that learned CTC MS A. Gayan is indisposed and undergoing medical treatment. On our behalf, the adjournment is sought for by
P. Rap.
MSP Rama. It is submitted that the matter be listed in the month of January. Mr. H. Pura Gohain, learned counsel, appearing for the petitioner, submit that interim order passed earlier. Be continued. Submit that matter be listed. Does not object to the prayer made. Stop accordingly. that the matter be listed in the month of January on a date to be fixed by the registry. It is made clear that the interim order passed on
Quite that was that
has been made absolute.
I think when I don't remember, but I have to check.
There is an order of 10/1/2020 saying that it will continue till disposal of the
Yes.
petition. So it by order dated 10/1/2020, it is already directed that the interim order passed earlier till the disposal of the list according.
I'm obliged. I look at it. Wait. Item next item 23, I think 20 is pertaining to yes, madam. A similar order would comment, madam.
There an interim order also.
Yes, madam. Even in that case also we have. Is there contiguous plots of land?
I look. Huh? I look.
I'm obliged.
May please, Lordship. The matter was filed, Lordship, at the time, Lordship, for the limited purpose, Lordship. So, Lordship, just we wanted direction, Lordship, as this 36 maybe seen, Lordship, to dispose of this petition, Lordship, by our representation. Because we are the mining contractor of a tender mining area, Lordship. In some period, Lordship, my area was stopped by the deputy commissioner. And when then there are some stop matters, Lordship, that is also watched by the plant, Lordship. Therefore, Lordship, although some of the similar situated parcels,
2016, you filed your representation.
yes, sir, based on disposal, Lordship, matter was pending.
Why 2016? Why are you waiting?
Matter was, Lordship, it was a big for Lordship, as usual hearing, Lordship, that's why it become.
No, no. It is in practice matter.
So now, Lordship, the
Now 2016 representation cannot be disposed of
now
today with a direction because the lot of
period is also over, Lordship.
not only period, lot of some situation, so many things may have undergone a change.
So now they
Heard
are
learned
not
counsel
interested,
for
Lordship.
the petitioner. This writ petition is filed by the petitioner praying for direction to the respondents number 5 as to why the representation dated 12/12/2016 submitted by the petitioner before the respondent 5. Where is that representation? Page
Page
number?
36, Lordship.
Huh?
36.
Seeking compensation for damage caused by flood over the mining work at NKD-B-4 Pudnabari Patthar area was not disposed of. So, the said representation, the petitioner was a mining contractor of NKD-B-4 Pudnabari Patthar area and was allotted to his name in 2016 for 7 years. Stop. Since the day of issuance of the contract, he has been paying all the installments. However, in the last part of May 2016, there was a flood in the mining area. And because of which he suffered losses as all the materials which were gathered in the mining area were washed away by the flood. According to the petitioner, his approximate losses suffered was to the tune of 8 lakhs, rupees 8 lakhs. Because of the thereafter, the The subsequently, when he came to work in the said area, uh, similar situated mining areas were issued by the respondent authority, but none was allotted to the petitioner. So it is his claim that he was not even permitted to work in the area. Therefore, the representation was filed. This matter has been pending disposal before the court pursuant to issuance of notice as far back as 29/5/2017. The respondent department has also not responded by filing any counter affidavit. Today, when the matter is listed before the court, counsel to the petitioner prays for an order for disposal for a direction to respondent number 5
Yes.
for a disposal of the state representation. So, upon careful perusal of the pleadings available before the court as well as the representation and petition, it is seen that the state representation pertains to uh, mining area allotted to the petitioner on in the year 2016. Stop.
The forest department.
Hmm?
The forest department.
Respondent 5 is whom?
This is the deputy commissioner.
Then why you are applying for the deputy commissioner?
The deputy commissioner is the as well authority of the district lordship. He issued the prevention order, lordship.
Where is that order in
That
your name?
order is lordship is 33 lordship. Third and fourth.
Now, where is the order of allotment of the mining area?
The allotment agreement is the lordship is there is contract. It is a 14 lordship. It's the agreement lordship.
This is with the divisional forest officer.
Yes, Lord. But our grievance is taken the deputy commissioner lordship. He issued the order.
Deputy commissioner has issued the order for closure.
Closer. Yes,
If
sir.
you have suffered losses, you go and apply before the forest officer.
Department, yes.
Why are you asking for the divisional forest officer? However, Kitilu Lasu was issued in the year 2016 for 7 years. Accordingly, this court does not consider it prudent to issue any direction to the respondent number 5 for a disposal of the representation seeking compensation. So, in any event of the matter, the contract agreement between the petitioner and the petitioner for the mining area was executed by and between the petitioner and the forest department, more particularly divisional forest officer, North Kamrup division, Romia. So, the district magistrate had only passed an order prohibiting extraction of gravel and earth cutting and silt from the beds and banks of all rivers of Borpeta till the flood season is over by its order dated 31/5/2016, and because of which order the petitioner claims to have suffered losses. So, there is no representation shown to have been addressed to the Forest Department for renewal of the contract, if any, in order to recoup his losses claimed to have suffered by him. So, under such circumstances, this court is not inclined to pass any order directing the district magistrate to pass any order on a representation filed on 12/12/2016. So, however, if any order of the said representation had already been passed during the pendency of the writ petition, a copy thereof shall be furnished to the petitioner. So, this disposal of the petition will, however, not preclude the petitioner to file necessary application before the Forest Department for highlighting any losses that he may have suffered and for which the department may consider his case for uh, 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 complying, for filing, uh, for considering his claim for due compensation as per the provision of law. Writ petition stands disposed in terms of the above.
25 days similar lot of money.
Similar order. Same representation.
Yes, but only the mining area is different.
Huh?
Only the mining area is different. Other than the data.
Mining area. Take the mining area. Yes.
All right.
Map list. What if senior counsel is in another court? Kindly matter.
What is the matter about? What is the matter?
Matter Torun Gustav.
Oh, missing case diary.
Yes.
Missing case diary.
Yes.
It will take it up on Thursday.
Right.
It's on Thursday.
Problem.
As it is submitted by the council, the Army Council, Mr. D. Mazumdar, learned additional legislator for the state, and Mr. N.K. Sharma Court. Correspondence with 4 and 5. Yes. Hmm? Yeah. Yes. Covered matter. Covered by the judgment.
Last occasion, the issue was regarding the same issue, the notice.
Oh.
Here also, the notice has been sent by the.
Yes. Any.
My lord, I just want to clear certain doubts, my lord. I heard the submissions made by the learned advocate. My lord, am I audible, my lord?
We're trying to be Yes, please.
Ma'am, I just want to clarify certain doubts, my lord. I heard the advocate appearing for railway and the submissions made.
Well, yes.
First of all, my lord, the Section 21 notice. My lord, the Section 21 notice has been issued by us. After that, my lord, from the advocate, my lord, they have given a go by to that because there has been subsequent correspondence to that thereafter.
Maybe, but then they are now raising this issue.
My lord, that has already been given a go by. They have not raised any objection to that.
Does it
Even
preclude us from considering?
Even thereafter, my lord. My
Does
lord,
it
if
preclude us from considering this issue now
Yes,
when
my
it
lord.
is raised before this court?
My lord, then my lord, if my lord kindly
If there is a view that this notice was never issued in terms of Section 21, merely because it was not highlighted at the relevant point in time, does it preclude the court from considering that it may not have been issued as per the provisions of the Act in the first place?
No, my lord. My lord, thereafter, my lord. My lord, if kindly sees Section 21. I'm
Yes.
just facing Section 21 again, my lord. Why Section 21 is important? It says when a dispute has arisen between a party and if there is an arbitration clause, what the first step a party has to do? It says, unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence. It says about the commencement of a dispute on the date on which a request for the dispute has been made. Now, when a request for the dispute has been made for arbitration and the parties have not accepted to that request, then comes Section 11, my lord. If my lord kindly sees Section 11. Next comes the role of the court in Section 11.
So request to be made by whom?
Request to be made by a party.
Party. Does the party include an agent?
My lord, that steps goes thereafter. That steps, the court in Section 11 is only going to decide if there has been, kindly see Section 11.6, my lord.
Yes.
Once.
Yes.
Where under an appointment procedure agreed by the parties. So there has been an appointment procedure agreed by the parties where a party fails to act as required under the procedure. So then the court comes into play.
No, we understand your arguments, but there is a objection
Then the Section
raised
21
to say that in order to exercise jurisdiction under 11.6, there must be a failure of the party under to appoint an arbitrator under Section 21. But 21 prescribes issuance of a notice and the failure of the party to act in accordance with the notice. Although there is no particular form,
there is no particular form, and this issue has never been disputed.
Respondent, of course, not in this matter, but in a similar matter, has raised this issue that party is defined under Section 2H, is
Yes.
it?
2-1. Yes,
2H, 21H.
Yes, sir.
That party means a party to an agreement. So, whether a notice issued by an agent would be considered to be
the arbitration clause is completely separate from the agreement, my lord. It's an independent clause altogether, my lord. It arises only when there is a dispute.
No dispute on that. We are only concerned is when does the jurisdiction of the court is to be invoked? On the failure of the party.
Here the jurisdiction under Section 11 arose when the parties has failed to act in terms of the conditions of the contract.
So that's
Then
right. So the party failure of one party will be from the date you fail to appoint an arbitrator after receipt of the notice. The question is who is to issue the notice?
My lord, to that the act is silent, my lord.
Sorry?
To that the act is silent.
That's right.
Because,
so there are some judgments. There are some judgments with reference to Section 34 to say that a party means a party to the agreement.
Well, that is in respect to when the award has been passed, the award has to be delivered to the party. It's very specific to that.
That's right. So party means a party. That interpretation.
There is no ambiguity in that. But here in section 11, the court is only entrusted with the power to see whether there is any arbitration clause and the issue is arbitrable or not. The court is
This will
only
require.
going to
This will require some attempt to understand whether party means a party or does it include the agent.
even thereafter, regarding the point of limitation, in section 9 also, in section 9 2, the limitation starts when there is an interim order passed under section 11, section 9. Here we have already got an order under section 9 and the limitation has started from there.
No, we are asking you on the objections raised by the respondents. There is no
Well,
other. There is no other
I
dispute.
think there is no valid point being raised by the advocate for the railway, my lord, because the court here in under section 11 is only going to see that whether there is any arbitration agreement or not, and if the parties has failed to appoint an arbitrator in terms of the agreement, the court is there to decide who will be the arbitrator. The court is only going to look into the matter as to the arbitrability of the dispute and nothing more.
But the power of the court is invoked on the failure of one party to appoint. That failure has to be counted from the date when the notice is issued.
Section 11 does not talk about that.
No, section 11 doesn't say so, but section 11 says on the failure of the party.
On the failure of the party.
Right.
So as and when the parties fail to appoint.
That's right. So your failure will be counted from after you receive a notice from 21. If you say that no specific notice is required under 21 is served, why do you say there is a failure? And where is the scope for the court to exercise jurisdiction under 11.6? Then we'll come back at 2.
Merit.
Actually, we are praying for 3 months. I think 2 months will do, Miller.
Yes.
Now, that is regarding the land acquisition. My lord, if your lordship would kindly come to page number 194 of the petition and 195. Please come to page 195, Miller. Now, that white building on top, there is a blue thing, that is my existing premises. And there are other shops which are yet to be cleared, Miller. This is a photograph of 1511. So, my lord, it's not that there's only because of me there. It is. I mean, there are other people also, Miller. My lord, it happens, Miller. That's my existing building. Of course. So, my lord, yes.
Lordship. Why? Yes.
Exactly.
Yes. What content we have to read, Miller? Why? Because this content, why it is required. The Lordship, due permission, I am reading. Only one paragraph, Miller. T notification that is already there. TG award already been taken. TD, TG, already been over. Yet Lordship appointed date was declared on 22/1/24. The project will be completed by 21/7/2026. At that location, flyover is to be constructed. The costing of flyover is about 30 crores. In case the petitioner is given further more time, it would not be possible to construct the said flyover. The flyover work can thereafter commence only from October 2025. There would be a delay of about 10 months on the project if land position is not given by Kala. The contractor is likely to claim idling charges, which is sitting idle, an arbitration claim amounting to rupees 15 crore on the public sector in case the land is not immediately handed over. Therefore, it is apparent that even after deposition of the compensation amount by NSA, the CLD petitioner yet to hand over the possession of the land even after 10 months. The petitioner, well aware of the fact after declaration of TD on 21/7/2020, the land has get absolutely in the central office, and the petitioner have granted.
Today is 26. Thirty-first of December. Okay, let it be 28 meters. Yes.
Lordship, only for humble prayer, Lordship, please, you understand? Because what happened, we see, no, that's correct. That is why, because maybe.
My lord, we are before a court of equity, my lord. We are before a court of equity.
Only because Lordship, as very beginning, I also said this is one project even this one. I'm not on that. Not only this instruction is to be little bit reflected, then thereafter your Lordship pleasure. And I said this.
One second, my lord.
No, please.
12, 11, 24 at page 188. Well, compensation has not been accepted as yet because, but anyway, that is a different. We are in the process of.
Definitely. Definitely.
Muted. Am I audible?
The losses will be taking up item number 28, 29, and 30, my lord.
28, 29, 30, yes.
Well, in this matter, the issue that has been raised by the respondent railway authorities is whether the notice issued under section 21 can at all be issued by an advocate acting on behalf of a party. Now, this is a question which has been now raised by the respondent railway authorities. Now, if your losses may kindly seize the section 21. Section 21 does not say per se कि the reference has to be made only by the parties. It says, if you losses may I place section 21 once, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent.
Mr. Counsel.
Yes, ma'am.
Perhaps you need to hear the objections of the respondent, because this
Yes.
issue was raised today in a different matter involving
My
in the similar issues.
My lord.
There are certain judgments which he is referred to, and also by the petitioner.
My lord.
So we'll request the court master to hand over copies to your counsel in Guwahati.
My lord.
Just go through it. In a nutshell, the arguments raised by the respondents, which is there in the earlier petition, not here in detail,
Yes, ma'am.
is that everywhere there is a reference of parties, and party is defined under 2H. Even under 21, it falls under the chapter 5 or 6. There, all other sections refer to parties. So therefore, if party means a party to the arbitration, then if a notice is to be issued which begins the arbitral proceeding, it must be construed that it ought to have been issued by a party. Whether an agent or a counsel will be sufficient to satisfy the requirement is the question raised, that since the since the provisions of the Act are very clear, doesn't call for any further interference. And in support of that, the judgment has been relied on in respect of appeal limitation in respect of an appeal under 34, where the appeal has to be made by parties. So the question is whether the notice served on the signatory of the that agreement or any other officer will satisfy the requirement of communicating the parties. So I suggest you perhaps go through this judgment, and then you may address the court on this issue.
My lord, I will definitely consider that judgment. I will address your lordship on this issue,
Right.
considering the judgment. The only thing, if I was pointing out to your lordship, is the language which is expressly provided in section 21.
We'll hear you.
My
We'll
lord.
hear you at on a particular day, whatever date is suitable for you. All we want to say is that since an objection has been raised to us, either we accept or we reject.
Yes, my lord.
So
And we will definitely address that
Right.
on that issue.
So when would you like to address the
Any,
court?
any day, subject to your lordship's convenience, any short date may be given. My lord.
We can have it on 5th of December.
My lord.
5th of December.
My.
Meanwhile, the court master will furnish the judgments.
Yes, to my learned advocate on record there, my lord.
You can just go through and revert back to the court.
My lord, grateful, my lord.
Heard, Mr. Your Mr.
Amit Nag, my lord.
Amit Nag.
Yes, ma'am.
Learned counsel. appearing through VC for the petitioner, along with Mr. S. Deka, counsel for the petitioners, Mr. H. Gupta for the railways. Since an objection has been raised by the railways that notice under section 21 is required to be issued by the party to the agreement and not by an agent, the court considers it appropriate to permit the counsel to the petitioner to address the court on this question. Let the matter be listed again for further hearing on 5th of December.
My lord, grateful, my lord.
It's here. Let's see.
We'll carry on with this hearing on 5th, I'm sorry, on 28th.
Mr. Senior Counsel.
Mr. Dotto
Yes,
will pick up this matter on 28th
20th December, November, my lord.
November.
I will be available physically, my lord, on 9th and 10th December. Is it possible?
Yes,
9th
of course it is possible.
It's 9th or 10th December.
9th or 10th. 10th of December.
My lord, my lord. Grateful.
Learned Senior Counsel, Mr. P. Dotto. Which that you'd like to address the court hearing physically on 10th of December. He is assisted by Mr. Davis and Mr. N. Ravi for respondent.
I am for respondent number 5, Lord.
On 5, Mr. S. Roy for respondent 5.
5.
Mr. Goswami for
2, 3, and 4.
2, 3, and 4.
My name may be shown in the cause list, Lordship.
The registry will reflect the names of all counsels, including counsel for the respondent of the court.
Public.
Grateful.
লই যাবে। Yes. Section 12(5).
Lordship, as per Honorable Supreme Court order, Lordship,
So are you going to do you want to submit anything that
yes, Lordship.
this is not applicable,
This is not applicable, not,
or
no,
the
Lordship.
facts can be distinguished?
Lordship, what happened as per the conclusion, Lordship, the Arbitration Act does not prohibit PSU from empanelling potential arbitrators. According to this order, Lordship, the railway can maintain an panel of arbitrator, Lordship. Yes.
But you cannot impose unless they
Yes,
waive.
Lordship. Second, this is one, Lordship, but regarding 3 members arbitrators, Lordship, they cannot impose that they have to go through our arbitration panel. If this is applicable, Lordship, in that case, Lordship, clause 63 and 64, Lordship, will not be enforceable, because as per clause 63 and 64 of the contract, general condition of contract 2013, Lordship, it relates to appointment of arbitrators from the panel. And there is no other option has been given in this clause 63, 64. So
The arbitration agreement is separate.
yes, Lordship.
Your other contract is separate.
Yes, Lordship.
The first thing to see is whether there is an arbitration agreement.
Yes.
Which means that whether the parties are agreed that you will like to refer the matter for go to arbitration once the dispute arises. Whether the dispute is arbitrable or not arbitrable, covered.
On merit, Lordship, it is not, it cannot be referred to arbitration, Lordship, because as per Dear notice, Lordship, they want referring of the matter for arbitration on the claim that they needs
Then
the.
we'll keep it for hearing day after tomorrow.
Lordship.
To argue on this.
Lordship. Because they want
Subject to correction, my understanding of the judgment is you can maintain, but you can't impose unless they waive.
Yes, that is what has been held, Lordship.
So if they have not given a waiver, they cannot enforce your any arbitrator from your panel. You cannot enforce. Either you have to agree with their arbitrator or you have to agree with some other name agreeable to them. And if you don't agree to any, then the application under 11.6. But the moment you fail to appear, ordinarily your power to appoint goes. You can't appoint now because you did not appoint.
Yes.
Lordship, clause 63, 64 mainly relates to the railway panel. So this clause will go, Lordship, with the application of this.
No, these clause will remain. But you, if they don't agree, you cannot appoint from this.
If they do not waive, Lordship.
If they do not agree, then you cannot enforce.
Lordship. In that event, Lordship, the mechanism also not, some mechanism has to be there, Lordship, to, from where it has to be.
11.6, that is the mechanism.
On merit, Lordship, the matter may be heard.
All right. Day after tomorrow?
Yeah.
28 for hearing. The request of counsel for railways.
All right.
Anything to submit or?
My lord, it's not very big, my lord.
Huh?
Here is a case, my lord. A criminal petition is going on, my lord, before the chief judicial magistrate to recover it at loan amount, my lord. For a moment, my lord, I want to.
What is your prayer here?
No, I'm for the respondent, lord.
What is the prayer in the writ petition?
Yes, Lord. Prayer is there, Lordship. The respondent bank has already freezing my account, Lordship, will not allow me to make transaction, Lordship. Actually, Lordship, my salary has been credited into respondent bank, Lordship, wherein my account, Lordship. Last 4 or 5 months, Lordship, I have not receiving any single penny, Lordship. Without getting any single rupees.
File an application, change your account.
Yes, Lordship. Yes, I have already filed, Lordship. That is my representation, Lordship, before the bank or.
They are not changing the account.
Yes, Lord.
No. Bank cannot change. You have to apply to your employer to change the account. Your salary account, you change it.
Yes, Lord. That is my liberty.
But have you applied?
But Lordship, the bank has.
You are an employee of the bank.
Yes. No, Lordship. Government employee.
Government employee. So you have to apply to your employer to say that you change this
My
account.
alternative.
No, my lord.
Yes.
Have you done it?
Yes, exactly.
You have done it.
No, Lordship. I will take necessary steps regarding
Take your necessary steps.
Yes.
My lord, my lord, what happened in this particular case, my lord?
We'll continue. Because if you want to argue on merits, then we'll have to
No,
hear
my
it.
lord. What facts he relied, my lord, that is not original, my lord. But
Whatever it may be.
my lord, what happened, my lord?
If your account is freeze, all right, you have a claim here to decide whether they can do it or not. But to say that no, my salary is going here, they are not allowing me, you apply for a different account.
But Lordship, already Lordship, almost 90,000 rupees has already been credited.
We are not closing it. We are not closing it. Your claim, whether it is entitled, not entitled, we'll examine it. But the prayer made that you are not getting your salary, not a penny is coming to you, is because you are not changing the account.
From today onwards, Lordship, I will approach before the appropriate authority to sending my salary account. But Lordship, already 90,000 or more
We'll
rupees
decide
has
it.
been.
We'll decide it. We're not saying we are closing your matter.
My lord, 2 minutes, my lord, to rely upon this facts, my lord. What even the petitioner has taken a 3 loan, my lord, from the State Bank, my lord. First loan was taken, my lord, on 4 lakhs,
That
my lord.
we'll decide it on the merit. We'll decide this on the merit. His contention is that whatever salary I am getting goes into that account and you are freezing it.
Why? That was just in the EMI. He was not paying that EMI, my lord. That is why, my lord.
No,
The agreement
out
is
of the
there.
5 lakhs 20,000 rupees, lordship, I have already been paid 4 lakhs rupees to them, lordship. Wherein on record itself, lord.
All right, we'll hear
Apart
the
from
matter.
your lordship, honorable Supreme Court lordship, clear direction, lordship. The bank has no right to forcefully taken action against the same, lordship. There is a provision framed by the statute, lordship.
We'll take it up on 10th of December.
So, lordship, stay order may be granted, lordship, not to deduct the amount which has already been credited into the respondent bank, lord.
No, how can that?
Your lordship.
What are you challenging here?
Your lordship, honorable.
What prayer he sought, my lord? Let them explain. What prayer, my lord?
What are you challenging here? What is your prayer?
My lord.
What are you challenging here?
My prayer is that, lordship, to release my salary account and
So
not to whimsically deduct that amount, lordship.
No, not to deduct this amount will be subject to for you to put a challenge to that to their conduct on the basis of any contract that they violated the loan agreement and thereby they have
Yes,
deducted.
loan agreement also violated. Can you be page number 17, lordship? Page number 17, that is the agreement, lordship. Kindly be see, lordship, in column number 6, lord. In the event of my failing to repay any 2 or more installment at any point of time, the bank may send written reminder or make call, SMS, or depute an office to meet me personally. All incident charges, appointment thereto, such as postage, telephone, SMS charges. No notice has been, no reminder has been sent to me. Only the whimsically seize my account, lordship, without
Let him
sending
finish, my
any
lord. Within
legal
5
notice,
minutes,
lordship.
I will cover the all facts, my lord.
I have no option. My salary has been credited into the respondent bank. Because of that, they have, without following the procedure, they have freezing my account. Is it the justice? The rule is governed by the statute, lordship. Honorable Appeals Court, even your lordship, the RBI, there is a guidelines, lordship, and procedure, lordship. And the rule has been already framed by the
Kindly allow 5
Reserve
minutes.
Bank of India, your lordship.
What happened, my lord? In this case, my lord, for a moment, my lord, kindly look to his annexure page 76, your lordship. In the writ petition, lordship, his petition.
Yes.
My lord, his representation, with due respect, I inform you that I have availed under Express Credit Scheme loan, height showing so. The same has been credited in my saving account showing so. The loan amount is 4 lakh. In the meantime, another 2 numbers of loan I have availed, 50,000 and 80,000 in different times, so online mood. Now, what prayer he sought, my lord? Page 13, my lord.
Yes.
My lord, it is therefore most respectfully prayed your lordship, please be issue rule calling upon the respondent bank to show cause as to why the writ of mandamana shall not be issued. Direct the respondent number 1 not to deduct any further amount without adherence assessment by the making it proper adjudication in respect of his loan account having its accounts number which was under respondent bank SBI Punjabari. Then next, lordship, and call for his loan account status report which was already been paid and not to deduct further amount from his salary by existing their so motto wisdom action fee till final disposal of the complaint case having registered under CR case number 774622. Now, lordship, currently this my lord, that case was placed before the National Loc Adalat. That orders, lordship, yes, lordship, in my reply, I have annexed. He agrees, my lord. He agrees.
$142.
Lordship. 142 is Lordship. Sorry, yes, Lordship. 143 is the orders, Lordship. Two loan in the meantime he has taken. One 4 lakhs and one loan is 80,000 Lordship. When he was not paid that EMI, several lapses is there, my lord. Then that case was placed before the National Local Adalat Lordship. The award kindly look into. The Biplav Gowai has attended the Local Adalat on 9/9/2023 and agreed to settle an account for 3 lakhs, upfront paid 10,000, remaining amount to be paid by 8/12/23. He was not paid anything, my lord. Then, my lord, what happened? What happened? There is another, we have given the ample opportunity to him to pay, my lord. 151 is the declaration. He said, I have regularly paid to 8,500. My lord, page 151. Here, in lordship, his signature is there, Biplav Gohai. I do hereby authorize you to debit at 8,500 rupees only on the civic bank amount so and so. Thereafter, my lord, what happened? 50,000 was given. He was, my lord, he said that within 6 months he will pay. Now, still now he was not paying. Now, what happened, my lord? Our reply is here, my lord. Please kindly look into my lord. Our stand, my lord. 85 lordship in para 11, 12 your lordship.
Yes.
That with regard to the affirmation made in paragraph 12 and 15 in the writ petition, the answering respondent begs to reply that the applicant
You file your reply here.
So, my lord, his agreement is there, my lord.
To the affidavit.
He was not filing that, my lord, reply.
You file your reply here.
Till then, stay order may be given.
What stay order you'll get, provided you file your reply. You have given an undertaking. File your reply. What do you have to say?
Lordship, all are already crystal clear. The affidavit filed by the respondent.
Somebody is taking loan, my lord, and loan he is not paying, my lord.
No, Lordship, I have already been paying 4 lakh rupees. That is on record, your lord.
Final hearing.
Can you be paid, Lordship?
On,
They have. So, Lordship, Reserve Bank, Lordship, already cleared.
Mr.
Notification has been published
make
by the
arguments,
Reserve Bank
as
of India.
per law. Your arguments will have to be as per law. You have given an undertaking. You have borrowed a loan from the bank and you have given an undertaking.
I admit, entire fact, I agree with you, Lordship. But their procedure ought to have been done by the respondent bank, Lordship.
What procedure?
The Reserve Bank, India, Reserve Bank, Lordship.
Are you saying that you have agreed that you will pay, and then you don't want to pay and you are questioning on the procedure? You don't want to.
There's a provision, Lordship.
You have not given. You have not given.
Lordship, my salary has been credited into the respondent bank. Only because of that, they have freezing my account. That is the justice, Lordship. The rule is governed by the statute, Lordship.
10 December for final hearing.
This
is not the way to conduct. Sorry.
My lord, my apparent.
Passport, Lordship. Really mentioned that, Lordship. There is a provision ought to have been.
Satisfy on the facts. You satisfy on the facts. You don't want to file a reply.
I have a duty bound to repay the outstanding amount. I admitted the fact, your lordship.
Please don't tell.
I admitted the fact, lordship. I am bound to pay, lordship. But procedure ought to have been done, lordship. At least, lordship, Reserve Bank of India.
Your matter is fixed on 10th. It's fixed on 10th.
My appearance may be, my lord. I am appearing for the respondent 1 and 2 cases.
For the respondents. Fixed on 10th.
Lordship.
Yes. What is this review? Yes.
My lordship, it may take a day after tomorrow if possible, my lordship.
Day after.
Published.